Be seated, please. We're here in State of Florida versus Segura, 2011-2751. Let the record reflect Mr. Segura is present with his attorneys. I guess the first thing we just kind of lay out some groundwork. I've had the deputy pass out an order of presentation. We don't do this very often, so just to make sure everybody's on the same page, that would be our order of presentation. Anybody have any questions or issues about that?
No, sir.
All right. I've sent you the preliminary instructions, which are just standard instructions, and the draft of the jury instructions. I was working on the verdict form. It gets a little complicated because we've got so many counts. But I have roughed out a verdict form. I'll have that sent to you, but would you give each of them a copy? So, a couple of things that we need to resolve. I guess first would be, what aggravating factors is the state going to be attempting to assert?
I think we have listed 6, Your Honor. One would be the defendant was previously convicted of another capital felony.
Huh?
That the murder was committed for the purpose of ordering lawful arrest, effecting escape from custody.
Which it doesn't involve escape from custody, obviously, so we
Yes.
strike that out.
Was committed for financial gain. Was heinous, atrocious, and cruel. Committed in cold, calculated, premeditated manner, and that three of the victims were under the age of 12.
Okay, and the state intends to proceed or assert as to all 6?
Yes.
Okay, all right. There were a couple of, I received a request for jury instructions. 3 jury instruction additions was first related to the contemporaneous conviction. Defense have any objection to that instruction?
No, Your Honor.
Appears to be an accurate statement of the law. You have case law on your second request, Mr. Evans?
Yes, Your Honor.
Relating to the witness elimination.
Yes, sir.
What's that?
Yes, sir.
All right. Let me.
Carrie, bring up the cases to you. And Your Honor, there's one thing I think I need to do right off the bat.
Okay.
Is on the first sentence where we're requesting the aggravating circumstances applies where it says A, it actually should be a D.
Where are you talking about?
Number 2, on the special requested jury instructions, number 2.
Right.
That first sentence says the aggravating circumstances applies where, instead of the A, that should be D.
Where the dominant motive for the murder was to kill a witness.
Yes, sir.
Yeah, I don't think there's any question as to the first sentence. I guess the second sentence is, where are you getting that from?
I'm getting it from the Howell case, Your Honor.
The what?
Paul Howell, which is 707 Southern 2nd, 647, Florida Supreme Court case from 1998. And around footnote 8, the language, I'm sorry, I have it printed out upstairs, but and I'm looking on page 7, Your Honor, and it starts talking about where asserting that the Howell asserts under headnote 5 on the right-hand side, it talks about him that the error in finding the arrest was committed to avoid, prevent arrest, and was also presented in that case that, and I'm looking at the paragraph close to the bottom, says Howell argues that in order for the aggravated to apply, that they're talking about Howell asserted that basically that there were other motives, that because there was some financial motive that was intended, that this should only apply if witness elimination is the dominant motive for the crime, but there were some other reasons that there should be. Court went on and held that it was permissible. It doesn't have to be the only motive. I'm looking on page 8. Toward the bottom of the page, I guess it would be on page 682 of the defense instructor. It says the fact that Howell may have other motives for murdering Bailey does not preclude the application of this aggravator. And it cites Fotopoulous, which is Fotopoulous versus State.
I see where you're referring to.
Yes.
Defense have any other authority on that issue that they want to assert?
No, when I saw that instruction, I thought it was an accurate statement.
Right, it would appear to be. All right, the third thing they've requested is a little bit confused. The statute says pecuniary gain, but the jury instructions approved by the Supreme Court talk about financial gain. And you've asked me to tell them pecuniary gain includes financial gain. I think they're probably synonymous. Seems to me it'd just be simpler to wherever we have the term that we use, financial instead of pecuniary, save us from having to define it, and that's what the standard jury instructions provide. Anybody have a problem with that?
No, sir.
No, that's what I was going to.
Okay. All right. I'm going to have to make some changes because I do have pecuniary gain in a couple of places. I have financial gain in most cases. So I'll grant the state's requested jury instructions. Number 3 will be done by just using the term financial gain instead of pecuniary gain. All right. So what other legal issues do we have?
We have the victim impact statement, Your Honor. Sorry I didn't get a chance to give it to you before we started, but I've got a copy for the court also to review. I think it's probably all in order.
Who is going to deliver it?
Monica Peters.
She's going to deliver it personally.
Yes, sir.
All right. So we need to be careful that she is cautioned that this is exactly what's to be said, and we don't need any emotional outbursts included in it. If she doesn't think she can read it without breaking down, then we need to make some other arrangement. I don't want to get into a big emotional outburst as part of the victim impact statement. So, I mean, she's welcome to do it if she can abide by those two things. I'm not sure that she can, but y'all need to discuss that.
Yes, sir.
All right. I'll read over this later. I assume you've reviewed it and it's appropriate. But with those two caveats, assuming I don't find anything problematic in there, we'll allow you to do that one way or another. Is that going to be the only part of the presentation you made initially?
Your Honor, I was also going to seek to admit and I don't recall if the complete autopsy report from Dr. Flanagan had been entered or not. I know some diagrams had been, but I don't know if her complete reports have been entered.
Well, I'm sure the report was not entered.
And so that it was just basically, if the defense doesn't have the objection stipulating the entry of those reports, then there'd be no necessity for calling Dr. Flanagan. I know hearsay is admissible and perceived to some extent, but
It's kind of admissible, but anyway, it's kind of not admissible too. But anyway, certainly she can testify to it, or we can put the report in. Do you have a position, Mr. Prince?
No, Your Honor, I'd like to talk to Mr. Evans about it. I didn't know they were going to make that request, so I'll talk to him about it, and probably we'll be able to work something out either way.
All right. Well, let's resolve this afternoon, because if they're going to object, we need to have Dr. Flanagan here.
yes, sir.
Okay. And that'll be the stage presentation, initial presentation.
Yes, sir.
Okay. In the aggravated factors, I started thinking, I mean, they have to be divided out by each count, so where we've got a count on count one involving Brandy Peters, I would think that I would take out reference to her being a child, essentially, I mean, since she's not. But I think the only place that would need to come out would be in the verdict form. Anybody have an issue with that?
No, Your Honor.
No, sir.
Looks like maybe I already did that, actually. Yeah, I already did that in the draft that you've received. What does the defense want in terms of instructions on mitigating circumstances? Have you decided that, Mr. Prince?
For the most part, Your Honor, I don't anticipate requesting anything other than the two the court looked at and identified and put in the proposed instructions.
I think those were the two you requested last time.
Yes.
And that's still satisfactory at this point?
Yes, sir.
Okay. All right. So what else do we need to resolve legally?
The only thing I would request is that, I know residual doubt is not a mitigating circumstance, so that it not be mentioned during the opening or any reference made to it by anyone who is presenting evidence or testifying, questions being asked about it.
Well, certainly lingering doubt is not a proper subject of argument. I don't know how it would come up as to a witness, but we'll have to deal with that question by question in terms of witness. But that's certainly an accurate statement that lingering doubt is not a proper subject of argument.
And the other two was the cost of the death penalty versus the cost of the death penalty versus life imprisonment. You know, financial factors on the state of how much it costs to impose the death penalty versus life imprisonment isn't a proper basis for arguing mitigation.
We're not going to put on any evidence or make any arguments pertaining to either of those things, Your Honor.
Cost, okay.
And the other would be the impact of the defendant's execution on the defendant's family. I don't think it's a proper basis to argue.
Mr. Mr. Prince?
We're not gonna put out any, evidence or argument on that, excuse me about that either.
Okay. All right, so grant those motion and limines. What else?
Nothing else, Your Honor, that I can think of at the moment.
Okay. Mr. Prince? Any other issues?
No, sir, I don't believe so.
How long do you think your presentation will be?
Not long, Your Honor. We'll finish tomorrow.
Okay. Has Dr. Pritchard, seen Mr. Segura now, or have we worked that out?
We've worked out 4 o'clock today is our goal for it to take place. Dr. Pritchard has given us that time, and Ms. Carruthers with the defense team is working to make that happen at the jail.
Okay.
It's set up, Your Honor. She's providing instructions to Dr. Pritchard's office. You can contact Captain Williams when he gets there, and he'll arrange a contact visit between Mr. Segura and Dr. Pritchard.
Okay. Okay. All right. So, any other issues?
Not from the state, Your Honor.
Not
Brent.
for the defense.
All right. So we'll resume at 8:30 tomorrow and proceed from there. Please, I mean, we don't have to have the instructions final now, but please look over them because they are, we're not real used to dealing with them, and I've tried to, as closely as possible, follow the standard jury instructions there. But anyway, make sure that you don't find any mistakes or any issues there, please. We'll see y'all at 8:30.
Your Honor, I did want to add something for scheduling purposes. When Mr. Prince said he should have his case wrapped up tomorrow, we anticipating giving it to the jury tomorrow?
Absolutely. We're
Yeah.
gonna finish it tomorrow.
That's what I just wanted to make sure that
Okay.
we were all on that same page.
Okay.
And Your Honor, just for record purposes, I have 4 discs here. Of course, we talked yesterday about supplementing the record. They are the testimony of Angel Avila, Kelsey Kennard, Officer Bossio, and then another disc containing the 2 state closing arguments.
Okay. Thank you.
Do we have any numbers on those?
3, 4, 3, 4, 5, and 6.
This will be court exhibits.
Recorded.
Court exhibit 3, 4, 5, and 6. Okay. All right. Anything else? If not, we'll see y'all in the morning.